Hi, my name is David Ricks, and I'm the Vice President of Fishing for Freedom. Our organization is comprised of over 2,500 individuals that have never experienced constitutional due process under the rule of the FWC. This DVD will give you clear evidence that anybody living under the FWC's constitutional authority has no chance to prevail in court. And if you read the legislative report by the FWC on their constitutional due process, the only avenue people have to appeal bad rules that affect the environment, economy, and citizens is the court. There's also evidence of what happens when an imperious form of government, that's the FWC, have no checks and balances and cannot be controlled by the executive, legislative, or the judicial branch. And Chief Judge Browning also mentioned that an agency like the FWC causes a lot of mischief. On this film, you'll see some of that mischief, but we have a mountain of evidence ready for investigators to take a look at. Our ultimate hope is that when you watch this video, you will be encouraged to support and sign on to House Joint Resolution 433 by Representative Needleman, which would create constitutional due process at the FWC, and any Senate joint resolution that would come along of the same nature. This constitutional abuse has gone on far too long. You have the ability to investigate our claims. Also, we pray that the Senate supports any resolution that's similar to House Joint Resolution 433. I've edited this tape for brevity and to show you the absurd rules coming from the FWC that cannot be defeated in a court of law simply because they state on record it's rational.
The only case that's really relied on by the Attorney General is the old 2-inch rule case, which went to an ALJ, and that concerned a seine net. The finding was the testimony of Mr. Brent Winter and Mr. Russell Nelson was that less than 5% of the fish caught would be bycatch, 5% max. Now we know it's 90%. Is that a problem? That's a serious problem for the resource.
What the trial court determined was that if the agency presents a rational basis for the rule on the record, then that's all they have to do. The hearing officer in paragraph 55 of the order, back on the rule challenge, said, quote, "No dangerous level of unnecessary killing or waste will occur, and the rule will enhance the overall fish population recovery effect."
Does the 2-inch net gill or capture, I'm not a fisherman, 90% of illegal fish? When they ran those tests,
when they ran the tests,
yeah, what happened?
I don't know the exact numbers, Your Honor, but that doesn't sound out of line.
In other words, 98 fish are unnecessarily killed and wasted for every 2 legal mullet caught in the FWC's net. We've lived under this absurd rule for 10 years.
Well,
their assertion
if I might ask a question.
I'm sorry.
I would like to know if the evidence that's been presented to the trial court was presented at the time the ALJ entered the ruling that you just quoted to me.
The specific test that they're talking about was not. The plaintiffs in that case, Your Honor, made exactly the same claim that they're making here. Paragraph 65, the hearing officer says, petitioners challenge the proposed rule because it will allegedly cause unnecessary killing, overfishing, and waste of juvenile fish. That is exactly what they're saying today, and she discounted that. She said that's not correct. The rule is valid.
Does the 2-inch net gill or capture, I'm not a fisherman, 90% of illegal fish? When they ran those tests,
when they ran the tests,
yeah, what happened?
I don't know the exact numbers, Your Honor, but that doesn't sound out of line. The uncontested statistics that are in the record here show that what the hearing officer found 7 years ago is borne out. It was found that the 2-inch net would not, and Mr. Rudlow testified at that hearing too, and he said the same thing in that hearing. And what the hearing officer found, as I read to you before, was there would be no unreasonable amount of unnecessary killing, and it wouldn't hurt the resource. That's what our experts continue to say. That's what our affidavits continue to say, and that's what the statistics bear out, Your Honor. That's the key thing here. This has been litigated. It was litigated in 1997.
Does the 2-inch net gill or capture, I'm not a fisherman, 90% of illegal fish? When they ran those tests.
When they ran the tests,
yeah, what happened?
I don't know the exact numbers, Your Honor, but that doesn't sound out of line. But there was evidence and opinion testimony presented to the hearing officer that allowed her to make those determinations.
The only case that's really relied on by the Attorney General is the old 2-inch rule case, which went to an ALJ, and that concerned a seine net. The finding was the testimony of Mr. Brent Winter and Mr. Russell Nelson was that less than 5% of the fish caught would be bycatch, 5% max. Now we know it's 90%. Is that a problem? That's a serious problem for the resource.
Why shouldn't it be considered when you get better data, newer data, and as I understand, your client agreed with the appellate to go out and test these nets, and when the results appeared to be adverse to your client's position, then the tests were terminated. Is that a
That is absolutely not what happened, Your Honor.
We have several witnesses ready to testify that the FWC broke the deal and admitted that no one could catch a fish with their 2-inch mesh net.
Those tests, the information that was gleaned from those tests was exactly what the agency expected.
If that's so, the FWC better explain why they have been enforcing a lie for 10 years. And why they have knowingly violated the Constitution while destroying the environment, economy, and harming citizens' lives.
Or let me ask you right there, has it ever been litigated that the 2-inch mesh net is illegal, as they're saying today? Has it ever been litigated in that respect?
Well, what was litigated was whether the choice of 2 inches was reasonable and not arbitrary and capricious.
All right, let me stop you right there, because I want to make a point. 90% were juvenile fish, which we say were illegal. You couldn't take them, couldn't harvest them. All right, what percentage did the 3-inch net accomplish? What percentage did they get?
Forgive me, Your Honor, I don't know. It's not for the court to debate the wisdom of the legislative determination, or in this case, quasi-legislative determination.
Well, let me ask you this, Counselor. Can your commission just do anything and we have no supervision over it, even if it's totally unreasonable?
FWC wisdom cannot be contested in a court of law, no matter how unreasonable. As long as the FWC states on their record that their rule is rational, the courts must accept it.